Share your sentence. Shareable graphic preview. I just sentenced Combs to 46 to 57 months. Offense level 23. Criminal history category 1. Transportation to engage in P. You be the judge. Federal sentencing calculator. What is your sentencing recommendation? diddydocket.com/sentencing. Entertainment purposes only, not legal advice. But I just find it funny that this came out literally 30 minutes before the document came out.
I ain't feeling them numbers, bro. Like, I know some of y'all think I'm a Diddy hater or whatever, and that's cool. But nah, bruh. And then not only did that BS come out, the response from the state, well, from the feds came out.
By electronic case filing, the Honorable Arnold Subramanian, United States District Judge, Southern Court of New York, 500 Pearl Street, New York, New York. United States versus Combe, S324CR 542 AS. Dear Judge Subramanian, despite this court's clear ruling that the defendant must be detained pending sentencing following his conviction on 2 felony counts, the defendant moves again for bail. After the court correctly found, after written and oral submissions by the parties on July 2nd, 2025, the defendant's detention pending sentencing is mandatory. There are no exceptional circumstances justifying his release. And even if there were, the defendant cannot demonstrate by clear and convincing evidence that he is not a danger to the community. That he is not a danger to the community. Yeah, they put a typo on that one. Further, following the court's unambiguous ruling, the defendant now seeks relief without even attempting to demonstrate a reason for reconsideration. Because the defendant's motion fails to demonstrate any of the required showings, he fails to carry his burden, and a motion should be swiftly rejected. The defendant has presented no reason for the court to reconsider its detention ruling. The defendant asked the court to reconsider its July 2nd, 2025 ruling that the defendant must be detained pending trial, but fails to even address the proper standard for a motion for reconsideration, let alone meet it. The court properly denied the defendant's request for bail on July 2nd, 2025, and the defendant has failed to present any reason for the court to reconsider its ruling. The court should deny the defendant's motion on that basis alone. Applicable law, where, as here, a defendant's bail application pending appeal was previously denied. A renewed motion for bail is properly considered as a motion for reconsideration by the court. See as noted, United States versus letter number 86, case 245. We ain't doing all that. Anyways, the Bail Reform Act is silent on when or if a district judge may consider his or her own detention order pending sentence. The judicial officer may at any time amend the order to impose additional or different conditions.
I'm going to be fair. I think this is going to end up getting pushed back even further. I think that's what's going to be the plan, is to have them sitting there just a little bit more, complete all of these programs, because in one instance, they did not do what they were supposed to do. What you talking about, Nash? There's no way that Diddy can apologize to Cassie and the 50 Cent baby mama at all. Can't contact them. Won't be able to. Then this is the part, and I thought people would understand, but I guess not. I think I need to start doing this every video, is basically telling y'all he got found guilty of 2 felonies. F what the felonies are for first. He got found guilty of 2 felonies. Let me ask y'all this simple question, because some of you people will say, yeah, but only if it benefits you or benefits your position, which ultimately benefits you. What person you know get found guilty and then basically they get to go? Remember that sad moment when Moontoon got found guilty of violating his plea agreement, and then everybody thought that he was about to leave and then had to turn himself in? I could break this news because it is what it is. They were thinking that Moontoon, his people, thought that he was going to be able to basically get his affairs in order and turn himself within 48 hours.
I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he
reinstating
will be
the balance.
continued on probation, Your Honor?
And reinstate the balance.
Your
Thank
Honor,
you.
might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right, bye.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Oh, wow.
Not on Zoom.
I don't know, the sound
Jolly.
of this.
I have not, and I'm not saying it doesn't exist, so I don't want people getting, man, you don't know what you're talking about. My uncle, 1978, and my daddy, 1998. Like, they did this, they did that. I'm not saying it hasn't happened. So let me give you that disclaimer. I've not seen it yet where somebody gets found guilty and then basically, bro, they get to go ahead and do their run. Not saying it hasn't happened, not saying it's not true, not saying any of that. I'm just not saying that I've seen it. So with that being said, what man is found guilty of 2 felonies and y'all think he just finna walk on out of there? I think what the feds are going to try to suggest is essentially this. All right, he got found guilty on 1. Let's agree to 24. Cool. But they're going to say double that one. 2 counts. Let's get them. Let's run them. Sorry, there's a call came in. Yeah, but let's run them. Let's run them. And then next thing you know, Diddy people going to be happy. And Diddy's lawyer's going to be like, yeah, let's run them concurrent. Or the feds go, no, let's run them consecutively. I think that's what's going to end up happening. I crystal ball Nash. I've been hitting on everything as of late. I don't see him getting no bail. I told y'all that. Some of y'all, well, this is that. And then y'all try to hit me with the double jeopardy stuff. And I'm just like, yeah, I hear you 100%. But dual sovereignty exist? Y'all like, oh shit. So I'm just gonna be honest with you. I think that's gonna be the ultimate plan. It's gonna come down to 24 months, and then the Fed's gonna say, yeah, 48. And that's gonna be the fight. I don't know what the hell that is. So Yeah, I don't know, man. Part of me wants Diddy to walk out of there and do like what's cuz name? Ray Lewis, that slide, yeah, yeah. And then spray oil all on the, you know what I'm saying, like he Triple H or something. But I just ain't seeing it, bro. And if I'm not seeing it, y'all could try to convince me, but where have you seen this stuff? Where have you seen a man convicted of 2 felonies in the feds basically just walk out right afterwards? Whether it's sentencing, whether it's probation / parole, whatever y'all want to, you know what I mean? Well, parole is once you basically been in there and coming out as far as the penitentiary goes. So basically coming out and getting some form of probation, I'm just not seeing it, bro. I'm not. And then some of you people were talking about, oh, well, the domestic violence stuff and all this stuff and everything like that. I don't know if y'all remember, but the judge specifically pointed out that they were able to introduce the domestic violence as a form of coercion. Now, if you want to argue and say, yeah, but Nash, he wasn't freaking convicted on that. So, yeah, it bears no weight. In that instance, I say you absolutely correct. There you go. Take your victory. Take your victory. I can't argue that one. If you wanted to argue that part, I'd have to say, yeah, you 100% right. But the thing about it is I think the judge went into the mental space of the victim, aka Cassie, with that damn letter. That letter was specifically drawn up to destroy him.
2nd, 2025, via electronic filing. Honorable Arnhem Subramanian, United States District Judge. Dear Judge Subramanian, we write as counsel for Cassandra Ventura, Miss Ventura, to respectfully request that the court deny Mr. Combs to be released pending his sentencing on his 2 convictions under 18 U.S.C. 2421 pursuant to the Bail Reform Act, 18 U.S.C. 1343A2. Detention is mandatory post-conviction on these charges. And Ms. Ventura believes that Mr. Combs is likely to pose a danger to the victims who testified in this case, including herself, as well as to the community. We want to thank the court for its time and attention to this matter. Respectfully submitted, Douglas H. Wigdor.
As far as his chances to come out. So I hear all y'all, but I think the judge was like, well, since basically she's been trafficked, she has a right to say, I don't want him in there. And the judge can't act like he didn't see that video. And if any of y'all want to argue that part right there, I got an ass whooping for you. Why is Diddy taking domestic violence classes, pardon me. Yeah. Checkmate, right? Checkmate, bitch! Gotcha. So I think the best course of action is for Diddy to keep on taking self-help classes and all of this stuff. And I find it funny, just to kind of show off my shiny gold medals, how some of y'all like, bro, you're not a lawyer, you're not this, you're not anything, you're not blah, 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 and all that stuff. You could go to Twitter or go to Instagram and see how I actually interact with lawyers. I've done this on my channel. If you don't think I don't know a lot of these lawyers, now I don't know Mark Agnifilo, but y'all damn sure know I know Brian Steele. Now I ain't give Brian Steele no advice on this or anything. He wouldn't take my advice anyways. Not saying that. But if you think that these lawyers aren't watching a lot of this stuff, then I don't know what the hell to tell y'all. It's not about everything they know. It's about the specificity in which you know. We've literally watched Young Thug's case where I literally said, bro, Adrian Love, she losing this shit. Why are you yelling? You're not even coming off likable to the jury. And we literally watched her slow it down. Start to walk Moontook ass down. And got his ass to break his plea agreement and sent him up the river.
Checkmate, bitch.
Not saying that was the intent for me, but if we being unbiased and calling balls and strikes, you as the audience, must understand something. Common sense ain't always common practice. If you want to be upset, then cool. No problem to it. But please, at least, consider what I'm saying. Click right here for the Lil Durk video, because I'm in 100% belief that these mother effers are trying to say that Vonnie is snitching with no proof. That they're trying to have the bloggers basically say this dude is snitching so the families of the other co-defendants can start to take plea deals against Lil Durk. It's pretty vicious, and we got the proof.